Hi guys, my name is Tejas Sudhakar K. I'm an advocate practicing in Bangalore and I'm a faculty at iProledge and I teach subjects of company law and CMSL for the CS Executive students. So today in this series, we'll be coming out with videos which typically students find it quite tricky or quite difficult, and we are here to simplify those topics in the best way possible and make you guys understand and remember it so that you can remember it till the exam. Okay, so yes, so today's topic, as you guys can already see, it is independent directors. So first thing, before we get into who are independent directors, why do we need them, okay, first let's understand who are directors and why do we need directors in the first place. Think about it. We all know that a company is an artificial person. So company cannot act on its own. That is, someone has to act on behalf of the company. See, company is an artificial person. It can do everything what you and me can do, but it cannot do some things. What? It cannot think, and there has to be someone who is acting on behalf of the company. And that's the reason directors are also called as the agents of the company. Why are they called agents of the company? Because they are acting on behalf of the company. They are acting for the company and behalf the company. Whatever actions that the company is taking, it is the directors who are approving. Now, you will get a question. Sir, if directors are doing everything what the company can do, then will they not do things which is more beneficial for them and not for the company? Right? This is a possibility, and this is where so many frauds that we have heard of happens. Why? Because they look after their own self-interest before the company's interest. Correct? So that is what is happening in case of all these frauds that have been happening. And to solve this, the Companies Act has a provision called as independent directors. As the name suggests, they are independent of the company. They do not have any close relationship with the company. They are not the shareholders. Their relatives are also not shareholders beyond a certain threshold. They are not the promoters of the company, right? And all these relationships are not there in case of independent director. See, think about it. If I was a shareholder of a company and I was also a director of the company, all the decisions I take, some or the other way, there is a possibility that my decisions will be motivated so that I make a financial gain out of it. But independent directors have nothing to lose. They are only there on their director's remuneration. They are only getting paid salary and they do not have shares in the company. So they do not have any other intention, right? So that is the reason we need independent directors on the board of directors of the company, so that things can be more transparent and there is more accountability in the company towards the shareholders. So today I will only be focusing on one thing: who can be appointed as independent directors, and literally nothing else. How many independent directors, all that is different, and that's comparatively easier and you guys can do it on yourself. But independent directors, now we are looking at who can be an independent director. Chalo, without delaying any more time, let's just get started. Okay, so now we understood who is independent director. Okay, but who can actually be appointed as an independent director? Section 149 subsection 6 of your Companies Act 2013 tells who is eligible to be appointed as an independent director. Tells you who is eligible to be appointed as an independent director. Okay, if you look at the definition, it is big, okay, and it is intimidating. It will scare so many students, but I have broken it down in the most simplest way possible so that it gets easier for you to understand and easier for you to remember. Broadly, they have given three points in section 149 subsection 6. Point number 1, point number 2, and point number 3. Okay, so point number 1 gives the conditions which will have to be followed by the person whom I am proposing to appoint as an independent director. Now I have given 6 condition. 1, 2, 3, 4, 5, 6 condition. Now these are the 6 conditions which needs to be fulfilled. By whom? By the person whom I am trying to appoint as an independent director. Okay, in our example, for our understanding, let's say Mr. A. Now if Mr. A should be appointed as an independent director, he has to fulfill these 6 conditions. Okay, then coming to point number 2. Point number 2 is Mr. A's relatives. Oh, now it's not just the conditions on the person whom you are trying to appoint as an independent director, but also on the person's relative, the person whom we are trying to appoint as an independent director, right? Who is it in our example? Mr. A. So his relatives also should comply with certain conditions. There are 5 conditions given. Okay, and then lastly, the third main point is both the person whom we are trying to appoint as an independent director and his relatives both have to comply with the conditions given in the third point. This is how you break down your section 149(6). 1. The conditions are for the independent director whom we are trying to appoint. Second, the relatives of the independent director whom we are trying to appoint. And the third condition, both the independent director we are trying to appoint, that is Mr. A, and his relatives, both of them should comply with the third point's conditions. Once you comply with all these conditions, then you can be eligible to be appointed as an independent director. Okay, so comply these rules, comply with these conditions, then we'll think about you are getting appointed as an independent director. Okay, if the company is fine after you complying with all these conditions, yes, you can be appointed as an independent director. So let's go ahead. So first thing, any person you are appointing, first point is the easiest point. You don't have to break your head. It's simple, straightforward, that the person whom you are trying to appoint as an independent director should have integrity. Great point. Of course he should have integrity. Even if he is not an independent director, he should have integrity, right? Of course. Okay, he should have integrity and possesses relevant expertise and experience. Too generic, easy to remember: integrity, experience and expertise. These are the 3 keywords of the first point. I hope you guys are remembering. Okay, and as and when I'm teaching, and even if you are at your house, okay, and I know I cannot hear you guys. If it was a physical class, I would have made sure that you guys tell it out loudly in the class and there's a chorus that's running behind. But as you are at your home, no matter what anyone thinks, let people think you have gone a bit crack. But I suggest you, please read it out loudly. Okay, and that's how you remember and retain things in a much better way, even for exam, not just for independent directors but for any other provision. Okay, first point is done. Now coming to the second point: who is or was not a promoter of LE is listed entity, HC is holding company, SC is subsidiary company and AC is associate company. So what are they telling? Whomever I am trying to appoint should not be a promoter of listed entity, listed entities holding company, listed entities subsidiary company or listed companies associate company. Okay, now to make you guys understand this better, let's say there is a company called as XYZ Limited. Okay, now Mr. A is supposed to be, they are considering and checking the conditions if he can be appointed specifically in XYZ Limited. XYZ Limited is a listed company. Okay, so XYZ Limited has ABC Limited, which is a holding company of XYZ Limited. Okay, then we have DEF Limited as its subsidiary company and LMN Limited as its associate company. So they are saying that Mr. A cannot be a promoter in XYZ Limited. Of course, if he is a promoter of XYZ Limited, how can he be called independent director? Okay, this is understood. They are saying that he cannot be a promoter of ABC Limited or DEF Limited or LMN Limited. Okay, so all these companies, he cannot be a promoter of all these companies. Okay, now you are seeing how the independence is building. I am not a promoter. Okay, in the listed company where I am proposed to be appointed, or its holding company, or its subsidiary company, or its associate company. Clear? Okay, but there is one line here, which is that line, who is or was. Who is or was. So both in the present and even in the past. Okay, so in the present you should not be an independent director, you should not be a promoter of listed entity, holding company, subsidiary company and associate company, and even in the past you should not have been a promoter of listed entity, holding company, subsidiary company and associate company. Clear? Both in the present as well as in the past, you, Mr. A, should not have been a promoter of these four companies. Okay, second point is clear. Now coming to third point, who is not related to promoters or directors in the, now Mr. A is not related to whom? To any of the promoters. See, first I should not be a promoter, and the third point is extension of the second point. What is the extension? That now I should not be related to any promoter or a director of the listed entity or the associate company or the holding company or the subsidiary company. Second point is I should not be a promoter. Third point is saying I should not be related to any person who is a promoter or a director in the company where I am proposed to be appointed as an independent director in that listed entity, its holding company, its subsidiary company and its associate company. Right? You understanding the flow? Okay, so point number 2 was with respect to Mr. A, and point number 3 is saying that you should not be a director. You should not be related to a director or a promoter of listed entity, holding company, subsidiary company or associate company. Now coming to fourth point, the person whom we are trying to appoint as an independent director should not have any material pecuniary relationship. Should not have any material pecuniary relationship. He should not have any material pecuniary relationship. Literally no pecuniary relationship. What do you mean by pecuniary relationship? A financial relationship. Let's say Mr. A and Mr. A and listed entity are entering into a contract for provision of services for consideration. This is a pecuniary transaction. Okay, where there is money involved. Now they are saying that Mr. A should not have any material pecuniary relationship other than his remuneration. If you guys have studied Companies Act, okay, there is section 197 which talks about remuneration for KMPs. Okay, in that, if you are getting that remuneration, it's fine. As a KMP or if you are getting that remuneration, it's fine. If you are getting remuneration, let's say tomorrow you get appointed as an independent director, tomorrow you are appointed as an independent director and you would be getting salary, no? That is fine. That is fine. But other than that, you should not have any pecuniary relationship with the company. Okay, let's read it. He has or had no material pecuniary relationship other than remuneration as a director. Okay, from the listed, the same thing, listed entity, holding company, subsidiary company or associate company. But here in the fourth point they have also given one more point, that is your time period. In the immediately 3 preceding financial years, and the current financial year. Okay, let's say I am proposing to appoint Mr. A as an independent director in 2025-26. Okay, of course here he should not have any material pecuniary relationship. Which year? 2025-26 financial year you should not have. And the immediately preceding 3 financial years, immediately. Okay, so 2024, 25, 2023, 24 and 2022 and 23. In these 4 financial years, there should be no material pecuniary relationship. With whom? With the listed entity, its holding company, its subsidiary company, and its associate company. Simple. And the fifth point is a brilliant point, that he should be of at least 21 years of age. See, here 2 points are very easy. The first point and the fifth point. Second point was with respect to he should not be a promoter. Third point was saying that he should not be related to any person who is a director or a promoter, right? And the fourth point is he should not have any pecuniary relationship. And fifth point is he should be of age of at least 21 years. Okay, then coming to the sixth point. Now, he is not an independent director of another company. Okay, now they are saying that Mr. A should not be a non-independent director. He should not be a non-independent director. So basically a normal director. Other than independent director. Let's say now we saw XYZ Limited. Let's say there is another company called as PQR Limited. There is another company called PQR Limited. In PQR Limited company, Mr. A is a non-executive director. Basically, he is not an independent director. What is he? He is basically not an independent director. Okay. Then there is one more person, Mr. B. Okay. And in PQR Limited, Mr. B is the independent director. Okay. Mr. B is an independent director where in PQR Limited. Okay. Now we call the sixth point to be the interlocking directorship. Listen to me carefully. So there are two companies. Okay. There are two companies. One is, let's say, now XYZ Limited and PQR Limited. Here also Mr. A is proposed to be appointed as an independent director in XYZ Limited, and even here Mr. B is there. We'll see in what capacity. Mr. A and Mr. B. Okay, now you saw the common thing. Mr. A, B are directors in both XYZ and PQR. Now Mr. A is proposed to be appointed as an independent director in XYZ Limited. This will keep it in question mark. This is yet to happen. Okay, this is yet to happen. Now, Mr. B in PQR Limited. In PQR Limited is a independent director. He is an independent director. Here is a non-executive director. Let's say non-executive director and not an independent director. Here he is not an independent director, and Mr. A here is a non-executive director. He's a non-executive director who is not an independent director. Isn't it interlocking now? See, the person here who is an independent director here is a non-executive director, and Mr. A who is proposed to be appointed, he is proposed to be appointed as an independent director. Okay, he is proposed to be appointed as an independent director. Okay, now he is a non-executive director in PQR Limited. You saw how is it conflicting? That is your interlocking provision. Clear? That is what your sixth point is telling. Who is not an independent, who is not a non-independent director of another company on the board of which any non-independent director of the listed entity is an independent director. In our case, Mr. B was a non-executive. He's not an independent director in XYZ Limited, but he's a non-independent director in PQR Limited. Okay, I hope these 6 points are clear. 1, there should be integrity, expertise and experience. Then the second point, he is not a promoter of listed entity, holding company, subsidiary company and associate company. Then the third point, this fellow should not be related to whom? To a person who is a promoter or director of the listed entity, holding company, subsidiary company or associate company, and he should not have any material pecuniary transaction, and he is of age of at least 21 years. And then the sixth point, he is not a non-independent director of another company on the board of which a non-independent director of the listed entity is an independent director. I hope the first point of the independent directors is clear. Okay, then coming to the second point. Now we are talking about the conditions that the relatives of Mr. A should comply with. Relatives of Mr. A. Okay, let's quickly go through these 5 points. First thing, Mr. A's relatives should not hold securities or did not hold securities, okay, both in the present as well as in the past. Holding securities of or interest, okay, either I am holding securities of the listed entity, holding company, subsidiary company and associate company. Clear? Either the relative is holding security of listed entity, holding company, subsidiary company and associate company, okay, when during the immediately 3 preceding financial years or current financial year more than 50 lakhs. So up to 50 lakhs in face value I can hold. Okay, up to 50 lakhs in face value I can hold. Okay, this is in face value. So up to 50 lakhs in face value the relatives of Mr. A can hold, or 2% of the paid up capital of listed entity, holding company, subsidiary company or associate company. I hope this is clear. Okay, so not in the past, not in the present. What should they not do? They should not hold security or interest where? In the listed company, holding company, subsidiary company or associate company in excess of 50 lakhs. So up to 50 lakhs I can have. Beyond 50 lakhs the relative cannot have. Clear? Then the relatives are indebted to the listed entity. So if I am saying I am indebted to someone, basically I have taken loan from that someone, right? So they are saying that the relatives of Mr. A should not be indebted to the listed entity, holding company, subsidiary company, associate company or the directors beyond a specified amount. Beyond a specified amount. Okay? Clear? I think second point is also clear. 3 immediately preceding financial years or current financial year. Okay? Coming to the third point. Now, what is guarantee? When someone else is taking a loan, let's say Mr. B is taking a loan from Kotak Mahindra Bank. So Mr. A goes and tells Kotak Mahindra Bank, boss, if this fellow doesn't repay, Mr. B doesn't repay your loan, don't worry, I'll repay. That is your guarantee. That is your guarantee. So they are saying that A's relatives should not have given guarantee or provided security in connection with indebtedness of a third person. See, second point is talking about the indebtedness of the relatives. In the third point, we are talking about indebtedness of a third person. See, we have Mr. A, XYZ Limited, and then we have Mr. B. So, Mr. B is the third person. Let's say XYZ had given loan to Mr. B. They had given loan to Mr. B. And Mr. A provided guarantee to XYZ Limited. Okay, saying that if B doesn't repay the loan, I will repay the loan. Okay, he should not have given guarantee to a third person, to the listed entity, holding company, subsidiary company, associate company, promoters, directors beyond a specified amount. During the 3 immediately preceding financial years or current financial years. See, this thing is the same. This thing is exactly the same. The only difference is the second point is talking about the indebtedness of the person you are trying to appoint as an independent director, whereas the third point is talking about the indebtedness of a third person in whose favor you have given the guarantee or security. Clear? Then, and the relative has any other pecuniary relationship with the listed entity, holding company, subsidiary company or associate company beyond 2% of its gross turnover or total income. Clear? I think second point is also straightforward. Now they have told no beyond a specified amount, beyond a specified amount, that amount is lower of 2% of its gross turnover or total income or 50 lakhs or higher or specified higher amount, whichever is lower. Okay, this is your specified amount. In these three, whichever is lower, that will be your specified amount wherever we have seen. Okay, clear? Okay, I hope the second point is clear. Now coming to the third point, Mr. A and his relatives. Mr. A and his relatives. Okay. Mr. A and his relatives holds or has held the position. What? Mr. A or his relatives. Now both of them should not have held the position of KMP or is or has been an employee of listed entity, holding company, subsidiary company and associate company. Now see, there is only one part which might trouble you all, which is holds or has. Here we are saying is or has. Clear? This is a bit tricky to understand. As I have told in the past, as I have told before, neither in the past nor in the present you should have been an KMP or an employee. Who shouldn't have been a KMP or employee? Both the person whom we are trying to appoint, that is Mr. A in our case, and his relatives. Both of these persons should not have been KMP or employee of listed entity, holding company, subsidiary company or associate company when during the 3 immediately preceding financial years or the current financial years of the appointment. And if a relative is an employee and he is not a KMP, this restriction does not apply for his or her employment. So basically they are saying that Mr. A cannot be both an employee or a KMP but let's say Mr. C is his relative of A. Then in this case Mr. C cannot be a KMP, but he can be, Mr. C can be an employee. This is not allowed, but employment is allowed for Mr. C. For Mr. A, both of these are not allowed. Clear? Second point, Mr. A or his relatives is been in employment or has been in employment, proprietor or partner, the same timeline during the 3 immediately preceding financial years or the current financial years or the current financial year. Now you should not be an employee, proprietor or partner in two kinds of firms. Okay, so again let's take Mr. A and Mr. C. Okay, now you guys know that Mr. C is the relative of Mr. A. Both of these persons now Mr. A nor Mr. C. Okay, what are they saying? They are not an employee, proprietor or partner. Where in a firm of two places, firm of auditors, company secretaries and cost and management accountants, and a firm of consultants or legal, what happened, or just a minute, or legal practitioners, okay, they should not be employee, proprietor or partner in these two firms. But there is a condition that they need to meet in case of. So the second type of firm has a condition. So the second type of firm will have to meet one condition for this rule to apply. See, what is the general rule telling that Mr. A and his relatives should not be proprietor, partner or employee in a firm of auditors, company secretaries or cost and management accountants, or they should not be partners, proprietor or employee in a firm of consultants or legal practitioners. The only issue that will come is with respect to this point. Now, what are they telling? That the gross turnover of this firm, which firm? The second firm. This is your first firm, this is your second firm. So the gross turnover to the second firm should not be more than 10%. Okay? If it is 10 or more percent, okay, let's say the gross turnover is 100 crores. 100 crores for this firm. Okay, it's a huge firm. So the 100 crores is its gross turnover. In that, 10 crores or more is coming from XYZ, from XYZ Limited, its holding company, its subsidiary company or its associate company. Okay, then if 10 crores or more of the turnover of this firm is coming from these four companies, then in that case they will not be allowed to be appointed as an independent director, whom Mr. A will not be allowed to be appointed as an independent director. I hope this is clear. Okay, but let's say, sir, if the turnover is only 8 crores, then no issue. Appoint Mr. A as the independent director for XYZ Limited. There I have no issues. There I have absolutely no issues. If it is 10 crores or more, then I have an issue. Okay, and in the first type of firm, turnover doesn't matter. So remember, turnover does not matter, is not relevant. Okay, now we have 3 more points. Who they hold together, who Mr. A and his relatives hold 2% or more of the total voting power of the listed entity, then automatically Mr. A cannot be appointed as an independent director. Okay, then Mr. A is a CEO or director by whatever name called of a non-profit organization. Let's say there's a non-profit organization called as Abhaya Foundation. Okay, there's a non-profit organization called as Abhaya Foundation. Okay, so there's Abhaya Foundation, and then we have XYZ Limited, and then we have XYZ Limited. Now we'll see what should happen. Okay, then they are saying that the non-profit organization receives 25% or more of receipts or corpus. For simplicity, what is receipt? Something that we are receiving. So non-profit organization in our example is Abhaya Foundation. Let's say it's receiving 1 crore, let's say, in one particular year. Let's say in one particular year, Abhaya Foundation received total donations. Total donations was 1 crore. was 1 CR. Okay. Now, they are saying that if 25 lakhs or more, okay, XYZ is donated to this foundation. Let's say XYZ Limited has donated either 25 lakh rupees or more than 25 lakh rupees to Abhaya Foundation. It has donated either 25 lakhs or more than 25 lakhs to Abhaya Foundation. Then what will happen? Then in that case, Mr. A cannot be appointed as an independent director. Mr. A cannot be appointed as an independent director. Okay, and who is Mr. A? Mr. A is the CEO of Abhaya Foundation. If Mr. A is the CEO of Abhaya Foundation and you are trying to appoint Mr. A as an independent director of XYZ Limited, but more than 25 lakh rupees, 25 lakhs or more than that is gone to Abhaya Foundation, then in that case, Mr. A will not be eligible to be appointed as an independent director of XYZ Limited. So this is how you can check the conditions of who can be appointed as an independent director and who cannot be appointed as an independent director, right? So I'll see you guys on the next video. Tell me which other topic do you want me to do it, and I would be more than happy to come out with the video for you guys. And all these notes that I have used in this video are available in the link mentioned down below. So make sure to hit like, subscribe and share it with your friends so that this apparently so difficult concept is easier for everyone. Just remember that independent director has 3 points. One, the first point is with respect to condition for the person whom you are trying to appoint. Second point is with respect to the relatives of the person you are trying to appoint. And the third point is about both the relatives as well as the person you are trying to appoint. So there are 3 different conditions given for in 3 different scenarios. Okay, I hope this is clear, and I will see you guys soon in the next video. Bye bye, signing off.